I did a talk towards the back end of last year about, it was a general overview on unfair dismissal. So if I know a lot of you weren't here on that, feel free to check that out. I will be covering a bit of the same ground, but what was clear from that webinar was that people wanted a lot more detail on sort of the subsets of grounds for dismissal. So today I'm going to be talking to you about misconduct in particular. Disciplinary matters and dismissals are unfortunately a fact of life when it comes to employment, and at some stage pretty much all employers will be faced with one or more employees whose behaviour is unacceptable. I'm here to talk to you about the key legal and practical issues that arise in that situation, and if you've got any particular questions as we go along, like Liz said, just type in the chat box and I'll do my best to deal with everything. We'll start by looking at what's likely to constitute misconduct and gross misconduct, and we're then going to look at how and when to take previous warnings into account, and finally we'll look at what procedures you should follow when investigating and disciplining for misconduct. So, the current provisions regarding unfair dismissals are contained in the Employment Rights Act 1996, which provide that the dismissal of a qualifying employee will be unfair unless the employer can show that the reason or the principal reason for the dismissal was a potentially fair reason, and misconduct, or rather conduct, is one of the potentially fair reasons, as we shall see. The second limb of the test is that the tribunal finds that in all the circumstances, including the employer's size and administrative resources, the employer acted reasonably in treating that reason as a sufficient reason for dismissal. So that means that the dismissal must be both procedurally and substantively fair. The ACAS Code of Practice on Disciplinary and Grievance Procedures applies to dismissals for misconduct or poor performance. It must be taken into account by tribunals in deciding whether an employer has acted reasonably in relation to following a fair procedure and giving fair warnings prior to dismissal. The code is essential reading for anybody involved in the dismissals process, and the code and statutory guidance can be downloaded free of charge from the ACAS website, and I've put the link up there on that slide, so do have a read. So, what is misconduct? Misconduct is one of the 5 potentially fair reasons for dismissing an employee, as I've already said. But what is it? Well, that's fact sensitive, and often really it's a matter of common sense. It's important, though, that you're clear as to the nature of the misconduct that you'll be dealing with. First, because it will inform what action you take, be that a warning or a dismissal. And secondly, because if you do decide to dismiss, an employment tribunal will look to see whether the misconduct was sufficiently serious in the circumstances to justify dismissal. This is where disciplinary rules come in. An employer ought to make clear, ideally in disciplinary rules in the employment contract or handbook, which types of conduct are unacceptable and may lead to disciplinary action or dismissal. Usually employers provide examples of what constitutes misconduct, particularly gross misconduct, but the employer is not expected to provide an exhaustive list. I'd recommend that if you do have a list of examples in your handbooks, that you specifically say it's not exhaustive, because whilst it's not expected that it is, an employer can be criticised for failing to make clear that certain acts will warrant instant dismissal, particularly where the facts aren't clear-cut and it's the employee's first breach of discipline. For example, there's the case of Lock and Cardiff Railway Company Limited. There, a train conductor was dismissed for putting a teenage passenger off the train in an isolated place when he was travelling without a valid ticket. The dismissal was held to be unreasonable in the circumstances and ultimately rendered the dismissal unfair, and the Employment Appeal Tribunal indicated that for a one-off error of judgment such as that, the employer ought to have been explicit that dismissal might follow. It's also important to remember that a dismissal will not necessarily be fair just because the misconduct in question is listed in the employer's disciplinary policy as something that might warrant dismissal. For example, John Lewis and Coyne, in that case, the fact that the employer's disciplinary code stated that making personal phone calls was viewed very seriously and might lead to dismissal, didn't exonerate the employer from its duty to investigate the seriousness of the offence in the particular case. Actually, in that case, the dismissal was unfair due to various procedural defects, and it was clear that the manager who took the decision to dismiss hadn't approached the matter with an open mind, since he regarded dismissal as the inevitable consequence of the offence. Don't do that. So there's a bit of a distinction. Of course, there's a general type of misconduct, but there's also gross misconduct. The term gross misconduct connotes the most serious types of misconduct, for example, theft or violence, and the types of misconduct that would warrant instant dismissal. What constitutes gross misconduct has been held to be a mixed question of fact and law, which means that nobody really knows. What the Employment Appeal Tribunal has said is that gross misconduct involves either deliberate wrongdoing or gross negligence. Gross negligence is a very rare head of gross misconduct. It's generally the deliberate wrongdoing that you'll find that employees unfortunately fall into. In cases of deliberate wrongdoing, it's got to amount to a willful repudiation of the express or implied terms of the contract. So, of course, different employers will take different approaches to whether or not something constitutes gross misconduct. For example, in a workplace where health and safety is of paramount importance, breach of a health and safety policy is likely to be regarded in a far more serious light than it might be in other organisations. So context is everything as to what constitutes gross misconduct. The important thing is that your employees know what the standard of behaviour is that's expected of them. I've brushed over really some particular types of misconduct that you might come across on a day-to-day basis, although of course I hope not. The first one I've listed there is refusal to obey instructions. That can constitute gross misconduct. Whether or not a dismissal for that is fair will depend on whether the instruction was reasonable, and the reasons for disobeying must also be considered. Another one is swearing. The sanction for that really depends on all the circumstances. For example, have a look at the culture of the workplace. Is there evidence that bad language is tolerated, or if it's commonplace? By way of an example, bad language in a garage could be viewed differently to bad language in an office or in a customer-facing role. And damage to the employer's reputation, both externally and internally, may be an important consideration. Also, was there a provocation? Has there been an apology? Can matters be put right? All of these are fact sensitive. Fighting is one which almost always appears in handbooks. It's usually reasonable for an employer to dismiss an employee for fighting in the workplace. However, it's important not to take shortcuts when considering the particular circumstances of the case. Equally, it's very rare, or probably impossible, to find somebody fighting with themselves. It is possible to fairly dismiss all employees involved in a fight without drawing fine distinctions between the relative culpability of those involved. But if you decide to dismiss some but not all of the employees involved, it's important that you can justify the difference in treatment to counter any allegations that particular dismissal is unfair because of inconsistent treatment. I am going to touch on this point about inconsistency towards the end of the webinar. Misuse of computers is increasingly becoming a disciplinary matter. It's essential that employers have a policy that clearly sets out the standards of conduct expected. For example, if personal use of the internet is permitted at work, it should be specified for how long and at what times this will be permitted. Social media obviously is a big buzzword these days. I'm going to talk about the use of social media shortly when we look at misconduct outside the workplace. And finally, dishonesty. Dishonesty will almost always undermine the trust and confidence of the employment relationship. And where trust and confidence has been lost, it always goes to the root of the contract, so that it would entitle the party who's been wronged, so here we're talking about the employer, it would entitle them to terminate the contract with immediate effect. There's an example of a case called Kengfak and London Borough of Southwark. There, a teacher claimed to be ill in bed when she was in fact working as a hairdresser on the side, and it was acknowledged that the dishonesty was so serious that it constituted gross misconduct. Some jobs, such as those where an employee has access to money, require the highest standards of honesty. It might not always be considered reasonable to dismiss somebody for stealing a very small sum of money, but it all depends on the circumstances again. For example, in Games Tech Leisure and McGee, it was held to be fair in the circumstances to dismiss a service engineer who had unsupervised access to fruit machines for taking just £3 from one of the employer's machines. So all of this means that you need to look at the nature of the business that you're dealing with, you need to look at the nature of the misconduct that you're dealing with, and really assess everything in the balance. It's not a case of one size fits all. Conduct outside work it may be fair to dismiss an employee for conduct outside of the workplace, so long as in some respect or other it affects the employee or could be thought to affect the employee when he's doing his work. An example of this kind of case is Eggleton and Kerry Foods Limited. There an employee was fairly dismissed for fighting off-site with a colleague. The fight took place in a car park across the road to the workplace, but Mr. Eggleton's conduct clearly affected working arrangements since the other employee concerned no longer felt safe to attend work. The fact that the dispute involved a purely domestic matter was irrelevant. It transpired that they'd in fact been fighting about a girlfriend. The EAT agreed that the employee's conduct had completely broken the employer's trust. Criminal misconduct outside of work. This is a really tricky area, and it's something which often provokes a knee-jerk reaction by employers. There is no rule that somebody ought to be dismissed because they're being investigated for, charged with, or have been convicted of a criminal offence. You need to look at what effect the charge or the conviction has on the employee's suitability to do the job and their relationship with their employer, their work colleagues and customers. ACAS have given some guidance for this kind of a situation in which an employer is considering disciplining an employee who's subject to a criminal investigation, charge or prosecution. The guidance is, and there's 5 bullet points, the employee should consider whether the conduct is sufficiently serious to warrant instituting the disciplinary procedure. And ACOS specifically says that off-duty conduct which has no bearing on the employment is unlikely to justify disciplinary action. The employer does not have to await the outcome of the prosecution before taking fair and reasonable action, so you're not held to the same standard of proof that a criminal court would be. In cases where the employee is not available for work because they're in police custody or indeed in prison, employers should decide whether, in light of the needs of the organisation, the employee's job can be held open. Of course, if they're not going to be there for a significant period of time, that may give rise to different practical considerations about whether they can fulfil their role. Where a criminal conviction leads, for example, to the loss of a licence so that continued employment in a particular job would be illegal, I'm thinking here of drivers in particular, then employers really ought to consider whether alternative work is appropriate and available before they simply dismiss for the loss of a licence. And finally, where an employee charged with or convicted of a criminal offence refuses or is unable to cooperate with the employer's disciplinary investigations, that shouldn't deter you from taking action. The employee needs to be advised in writing that unless further information is provided, a disciplinary decision will be taken on the basis of the information available. Right, social media. The proposition that conduct may damage the employer's reputation, even if it takes place outside of work, is particularly evident when it comes to social media. Cases of this nature usually relate to conduct outside of work in the sense that employees are accessing their Facebook and Twitter accounts or whatever in their own time. In cases where employees are doing unacceptable things with social media in working time, they may fall to be characterised differently as misuse of computers. Surprisingly, actually, there haven't been a lot of cases involving the use of social media outside of work, but those that have been reported tend to suggest that employers shouldn't take a disproportionate view of the damage or the potential damage to their reputation merely because conduct that doesn't put them in the best light comes into the public arena. The information given to employees about corporate image and reputation, as well as its expectations as regards the use of social media, are also relevant. The question of whether the employee's usage of social media is work-related will depend entirely on the facts of the case. But if you've got a computer policy, given the age that we are now living in, I would strongly recommend that you put in a paragraph there about the acceptable and unacceptable use of social media in and out of work. So I've gathered a few examples of some cases involving social media, just to give you a flavour of how employment tribunals are viewing these kinds of cases. In Game Retail Limited and Laws, the Employment Appeal Tribunal held that a dismissal for offensive non-work-related personal tweets was potentially fair. The employee was followed by 65 of his employer's stores and had posted 28 offensive tweets containing expletive and obscene language on his personal Twitter account. But then in the Scottish case of Taylor and Summerfield, It was unfair for Summerfield to dismiss a manager for posting a fairly innocuous video on YouTube of an employee in uniform being bashed over the head with a plastic bag full of other plastic bags in an anonymous storeroom. The video only received 8 hits. It was taken down by the manager after 3 days, and he later apologised for his error of judgment. The tribunal found that it was outside the range of reasonable responses for the employer to characterise that as gross misconduct, as there was no evidence that the video had caused or was likely to cause damage to its reputation. Further, the dismissing manager had failed to consider alternatives to dismissal and hadn't taken into account mitigating factors such as the admission of guilt, the apology, and his unblemished record. Witham and Club 24 Limited, there an employment tribunal held that dismissal of an employee for making derogatory comments outside of working hours about her workplace on Facebook was not reasonable and so was unfair. The comments were relatively minor. There was nothing to suggest that the employer's relationship with a key client had been harmed or jeopardised as a result. And interestingly, in that case, the employment tribunal seemed to draw a distinction between Twitter and Facebook, suggesting that Twitter is a more public domain than Facebook. Whether I agree with that, I'm not entirely sure, but it's an interesting comment nonetheless. Finally, Crisp and Apple Retail, it was critical to the tribunal's decision there when they found that it was a fair dismissal, that Apple had made it clear in its policies and its training materials that protecting its image was a core value, and had drawn attention to the fact that making derogatory comments in social media was likely to constitute gross misconduct. So again, we're getting back to that theme of making sure that the standard of behaviour is known by your employees. Previous warnings. Again, context is everything. In the absence of gross misconduct, dismissal of an employee for a first offence is very likely to be unfair if they haven't previously received any warnings. When you're deciding the appropriate penalty, employers can take into account any live warnings on the employee's personnel file. They may only take into account any expired warning and the underlying misconduct, where that's not the principal reason for any subsequent dismissal. So in other words, where the circumstances would have justified dismissal anyway. Employers may also take into account warnings that were only given after the later offence. For example, in Sweeney and Strathclyde Fire Board, the employee was dismissed for misconduct that would not on its own have warranted dismissal because there was already a final written warning in place. And the final written warning was issued for something which happened after the first matter of misconduct which he was dismissed for. The EAT held that the employer could take account of that warning, even though it had been given after later misconduct had taken place. The ACAS code, we've already touched upon that. That applies to disciplinary procedures for misconduct. The code envisages a staged process whereby someone will usually receive a first, usually written, warning for misconduct, followed by a further or final written warning if there's a further lapse. However, if an employee's first misconduct is sufficiently serious, it may be appropriate to move either directly to a final written warning or even on to dismissal. What the ACAS code is silent on is whether it is permissible to dismiss someone where they've received a first written warning, followed by a further act of misconduct which is not gross misconduct during the currency of that warning. Some employers may choose to regard that second act of misconduct as tipping the balance in favour of dismissal, regarding the previous warning as the background against which they judge the subsequent misconduct. However, the ACAS code only refers to the more clear-cut scenario of dismissal being fair when someone commits a further act of misconduct during the currency of a final written warning. Perhaps the reason for that is that a final warning carries with it, either explicitly or implicitly, the warning that any further misconduct will be met with dismissal, whereas a first warning doesn't. Moving from first written warning to dismissal for a next offence which isn't gross misconduct could be risky, since an employee may be able to argue that they were prejudiced by the absence of a final written warning. Employers sometimes use verbal warnings for less serious matters than written warnings, or sometimes as a preliminary stage to the giving of a written warning. And the status of your warnings will largely be determined by what is said in your employment contract and your disciplinary code. However, tribunals have held that there's no special magic in a written warning. In the case of McCallum and Castleton Crafts, the employee had received several verbal warnings for misconduct. He carried on with the behaviour and then he was dismissed. He challenged the dismissal on the basis that he'd never had a written warning, only verbal warnings, but the tribunal were unsympathetic. They said there's no special magic about a written warning. To an intelligent man, a verbal warning should be just as effective. The only advantage in a written warning might be for evidential purposes later on. So bear that in mind if you're presented with a perpetual perpetrator. Just a quick point on live final warnings. The relevant date for assessing whether a final warning is still live is the date of the conduct leading to the dismissal, not the date of the dismissal itself. In the case of Bevan Ashford and Mallin, there was a warning dated the 29th of January 1992, which stated that it would remain in force for a period of 12 months from the date of this letter. So on a proper construction of that letter, it was live until midnight on the 28th of January 1993. The EAT held that the live period of a warning should be construed strictly against the employer, and the warning couldn't then justify the dismissal of an employee for conduct which occurred on the 29th of January 1993. So it really is important to make sure that you read any final warnings very carefully. Where there's a final warning that's still subject to an undecided appeal at the time of the subsequent disciplinary proceedings, exercise some caution. There's no rule that the warning has to be ignored or that you can't dismiss until the appeal is determined. However, the fact that there's an outstanding appeal is a relevant circumstance for the tribunal hearing an unfair dismissal to claim to take into account. So whether dismissal was reasonable might depend on the timescale. If the appeal is due to be determined the day after the decision to dismiss, that's probably unreasonable. But if the timescale is in weeks or months, then circumstances might be different. Let's look at procedure. The question of whether or not a dismissal was fair has to be determined in accordance with section 98.4, which we touched upon earlier, and which is on that slide there. That requires a consideration of all the circumstances, including the size and administrative resources of the employer. So a little one-man band is not going to be held to the same standards as a huge multinational corporation, albeit that you don't get a free pass either. The question of fairness also has to be determined in accordance with equity and the substantial merits of the case. The tribunal will have regard to whether the employer carried out a reasonable investigation and, importantly, whether it held a reasonable and genuine belief in the employee's guilt. The ACAS code, which we've already talked about, applies to dismissals for misconduct. That's going to be taken into account by tribunals when deciding whether a dismissal is fair, so follow it. Many principles will be familiar to you, but I can't stress this enough. Please read it. According to the ACAS code, before dismissing for misconduct, an employer should investigate the issues, inform the employee of the issues in writing, conduct a disciplinary hearing or meeting with the employee, inform the employee of the decision in writing, and give the employee a right of appeal. Investigation. The first step in the disciplinary process is to investigate the allegations made against the employee in question. The investigation must be reasonable. There are no hard and fast rules. Employers have a certain latitude as to what constitutes a reasonable investigation. And I keep saying this, but the degree of investigation required very much depends on the circumstances. While an employer may be criticised for failing to investigate thoroughly enough, it's never likely that an investigation will be held to be unreasonable because it's too thorough. An employer should assess its approach by taking into account the strength of the prima facie case against the employee and the seriousness of the allegations and their potential to blight the employee's future. As regards the strength of the prima facie case, obviously you're going to have scenarios which fall somewhere on a spectrum. At one extreme, there are going to be cases where the employee is virtually caught in the act. At the other end, there'll be situations where the issue is one of pure inference, and as the scale moves towards the latter end, the amount of inquiry and investigation that's required is going to increase. An investigation should be particularly rigorous when the charges are particularly serious or affect the employee in a far-reaching fashion. For example, where the case involves serious allegations of criminal misbehaviour, and there's plenty of cases about this regarding, for example, teachers having relationships with pupils. A thorough investigation is required then. Also, if you may be making a decision which would impact upon a person's right to live and work in the UK if they are dismissed, again, a very thorough investigation can't be recommended enough. It's important that your investigation is even-handed. It has to be even-handed to be reasonable. In cases that can result in dismissal, particularly where the employee has been suspended and has no access to witnesses during the investigation, it shouldn't simply be a case of searching for evidence against the employee. You should also include evidence that may point towards innocence. Even-handedness may mean following up aspects of a witness's evidence that raises an unanswered question. For example, if it's inconsistent or it appears to conflict with views of others. An example being Salford Royal NHS Foundation Trust and Roldan. There, a nurse from the Philippines was alleged to have abused a patient in a number of ways. If upheld, the charges would not only cost her her job, but they would have been reported to the police, and they would have resulted in her losing the right to work in the UK. A senior manager interviewed Ms. Roldan and a colleague who claims to have witnessed the events. The manager made really lengthy notes of the investigatory interview with Ms. Roldan, but no interview notes were made with the colleague. The employer's disciplinary panel found that Ms. Roldan's evidence was unconvincing, preferred that of the colleague, which they found to be reliable, primarily on the basis that they couldn't see any reason why she would lie. Ms. Roldan was dismissed, and she brought an unfair dismissal claim. And the tribunal found that the dismissal was unfair. It held that the employer should have made further inquiries into the colleague's evidence and should have questioned other witnesses about the claimant's interactions with the patient in question in order to test that evidence. All that being said, whilst you do need to be even-handed, you're not obliged to explore every single line of inquiry or to leave no stone unturned. Where the employee admits to misconduct, you're not usually required to conduct an investigation, but that's not a hard and fast rule. The test for a tribunal is going to be whether the employer acted reasonably in all the circumstances, and sometimes that may entail conducting an investigation. For example, where new matters come to light, it may be that they've admitted it, but they're covering up, or there's a suspicion that they're covering up for somebody else. One area where the usual test of fairness won't apply is, sorry, I'm just losing my way on my slides there, is where there are several suspects to an offence, so misconduct by one of a group. That's because the employer may not be able to establish belief in the guilt of a particular employee, but they know that somebody is guilty. In such cases, you can fairly dismiss all members of the group of suspected offenders, even if that inevitably means that you will be dismissing somebody who did not carry out the misconduct. Case laws establish that the employee can dismiss all of the suspects, provided that an act has been committed which, if it was committed by one person, would justify dismissal. The employer has made a reasonable investigation into the matter. As a result of that investigation, the employer reasonably believed that one or more of those persons could have committed the act. The employer acted reasonably in identifying the group of employees who could have committed the act, and each individual is capable of doing so. This is not a blanket permission for simply dismissing your entire workforce. And as between the members of the group, the employer can't reasonably identify the individual perpetrator. Where any one of a group of employees could have committed the offence, the fact that one or more of them was not dismissed doesn't mean that the dismissal of the remainder of the employees is unfair, but that's provided that the employer has grounds for differentiating between the different members of the group. There is no all or none principle in this group situation. Key here is being able to justify your difference in treatment of anybody. So if in doubt, write it down and keep good records just in case they need to be scrutinised later. So dismissing fairly for misconduct. The employer only has to show that it has a genuine belief in the employee's misconduct to establish that the conduct is the reason for the dismissal. That's so even if you're wrong. If your belief is mistaken but it is genuine and it is based upon a reasonable investigation, that is sufficient grounds. As we've already touched on, in order for there to be a fair procedure, an employee has to be made aware of the case against them. They have to have the opportunity to state their case, and they have to be afforded the right of appeal. That's a basic principle of natural justice. The ACAS code goes a bit further, in particular providing that the employer should go through the evidence with the employee, and also that the employee should be allowed to call witnesses. This is, without a doubt, the most important aspect of procedural fairness. It's important at the stage that the charges are put, and it's also important when the employee is provided with supporting evidence of the allegations. A bit of advice: when you're putting an allegation of misconduct to an employee, give them enough information to be able to put their side of the story, but if you can, avoid using emotive language to describe an allegation. For example, accusing an employee of theft or fraud. What matters is that the employee understands the substance of the allegation so that they can respond to them. And it's really important that you set out the specific facts that you're relying upon. When you get to the disciplinary hearing, it's important to give the employee an opportunity to answer the allegations put to them. They ought to be allowed to call witnesses. Some changes can be made. If, for example, there is an allegation that an employee has been violent towards another employee, it would not necessarily be unreasonable to refuse them the right to cross-examine that person, the victim, the alleged victim. But certainly steps should be taken. For example, invite them to write down a list of questions that they want answering, and then for an HR consultant to go and speak to that particular witness. They're entitled to have their say. They're entitled to present their evidence. So don't take any shortcuts. Also, don't forget that the employee has the right to be accompanied at any meeting by either a trade union representative or a colleague. Final bullet point there on this slide is keep careful notes. If this gets as far as an employment tribunal, your notes will prove essential in the event that the process is challenged. Substantive fairness. Was it reasonable to dismiss in the circumstances? So employers have lost cases where, despite having followed a fair procedure, they haven't persuaded an employment tribunal that dismissal was a reasonable sanction in all the circumstances. The tribunal will look at whether the decision to dismiss was in the range of reasonable responses that a reasonable employer in those circumstances and in that business might have adopted. It's not for the tribunal to say, well, we don't agree, so we'll substitute our own view. If they do that, you can appeal. But you have to be reasonable. It can be a bit of a minefield, this, and I know one of the questions that was put forward before the webinar was, well, how do I know what sanction to give when there are so many different types of misconduct? Again, weigh everything in the balance. Look at your disciplinary code. Have they had previous warnings? If it's not misconduct, it's probably a case of either a first warning or a final written warning, depending on the severity. The following circumstances probably relevant to deciding whether or not to dismiss. The relevant background to the offence, for example, previous warnings or similar incidents, the employee's length of service, prior disciplinary record, whether the employee admitted the offence and showed remorse, and whether the employee was provoked or acted under stress. I've already touched on this, but while some offences are so serious that dismissal is in fact the only realistic option, it will probably be unwise for you to say in your dismissal letter that dismissal is the only option, even in gross misconduct cases. Employers do need to be mindful of their duty to consider all the circumstances and other options to dismissal, such as final warnings, or consider a demotion perhaps, but only where your contract of employment allows this. You can't simply demote people without that clause being in there. To establish fairness, an employee should be able to, sorry, Liz is waving at me whether or not to move the slides on. To establish fairness, an employee needs to show that they've considered mitigating factors. In that regard, it's good practice to invite the employee to say anything by way of mitigation after announcing a finding of misconduct or gross misconduct, but before you make your final decision. Final thing is consistency. It's important to consider the level of sanction that has been imposed on other employees in the company in similar circumstances and act consistently with previous decisions unless there is a material difference in the circumstances or in the offence. An employer ought to be prepared to justify any difference in treatment, for example, on the basis of mitigating circumstances or difference in length of service. An employer's previous decisions not to dismiss employees for the same misconduct will only make a dismissal unfair in 3 types of case. One, where those decisions have led employees to believe that certain categories of conduct will be overlooked or will not lead to dismissal. Secondly, where it can be inferred from those decisions that the employer's asserted reason for dismissal in this case is not the real reason. And thirdly, where a decision in truly parallel circumstances supports the argument that it was not reasonable to dismiss in this case. The test for tribunals to ask whether the employer's differential treatment of the employees was so irrational that no reasonable employer could have taken that decision. So, to summarise, It's been a bit of a whistle-stop tour again, I'm afraid, but if you are faced with an instance of misconduct, you need to do the following. Investigate the allegations, have a meeting with the employee, consider the relevant background and mitigating factors, consider what the appropriate sanction is, act consistently, confirm the decision in writing, and allow an appeal. My final, we're a bit behind on the slide, sorry. The final slide I've put in there is the procedure for claiming. I touched on this in the last webinar, and we had a long conversation there about early conciliation. So I'd refer you back to that in respect to procedure. But basically, an employee's got to go through ACAS first. If it doesn't settle through ACAS, they have to issue their claim within 3 months minus a day. And then if they are successful after tribunal hearing, they can claim reinstatement, re-engagement, or compensation. So that is a whistle-stop tour of misconduct. Has anybody got any questions? I think I've covered all the preliminary questions that were raised, but if there's anything that's cropped up, if anything's cropped up as I've gone along, do feel free to jump in now. What should an employer do if during the disciplinary process the employee gives in his notice? However, the way the disciplinary was going, no penalty was going to be imposed. Well, that's really a matter for them. It's perfectly common, actually, for people to hand their notice in as a matter of, well, generally a knee-jerk reaction. You don't have to complete the I've got a bit of talking in my ears. I'm not really sure what's going on. It's not unusual for that to happen. You don't have to finish the disciplinary procedure, but I would recommend that you do, because equally it's not uncommon for people to come back and say, actually, I made a mistake, I acted rashly, can I please be reinstated? You don't have to. You don't have to accept them back, but it probably was a knee-jerk reaction. So go through the motions and say that we know that you've resigned, but here's our decision in any event. I'm just being asked to bear with us 1 second, because I need to mute everybody, and that's going to mute me as well.
To unmute your line, press *6 or #6.
Hi. Is there any case we can read on misconduct by one of the group? The answer is probably yes, but I haven't written a case name down. If you want to drop me an email at the email address on the screen, and I can get back to you on that, that's fine. There was a lot of talking, noted, Flora. It was my understanding that an employee had 28 days after being issued with the ACAS early conciliation certificate to lodge an ET1. Is this incorrect? Yes, Tracy, that's incorrect. It all depends on the circumstances. ACAS early conciliation, if it takes place within the 3 months limitation, what effectively it does, it suspends limitation. So once the early conciliation certificate has been issued, time then starts to run, and it's still 3 months. However, if limitation would expire within 1 month from the date of the early conciliation certificate, then limitation is extended to 1 month after the issuing of the certificate. So that's where that point has come in. It's not a one-size-fits-all situation. It all comes down to how long they have in terms of limitation after the issuing of the certificate. I hope that makes sense. Typing away. Yeah, great. Is there anything else that anybody wants me to assist with? Yeah, I am doing another webinar next month. We're going through lots of different grounds for dismissal. Next time I'm going to be talking about dismissal on grounds of capability. That's the 10th of February. what we're going to be touching upon there, you should have got the information in a mail shot, is primarily procedures for dealing with people who aren't coming up to scratch, but also then we'll look as well at people being off sick for a long period. Janet, regarding your query, would I give the employee time to reconsider their notice? Personally, no, but that might be cynical. If they are gone and they seem to take the view that it's the relationship's completely broken down, then that's absolutely a matter for them. If they come back to you within a short period and say, actually, particularly if they're working a notice period, if they've just resigned and never come back, then I would get a shot of them if I'm honest. But if they are still working their notice period, then do go through the disciplinary procedure with them, and it may be that prompts them to ask you to reconsider. If you want to keep them, then yes, it's all a matter for you really, and good management. But good management depends on how good your employee is, of course. Another one. Would you continue with the disciplinary process if resigned, if it was likely that you would have dismissed or given a final written? Yes, Mona, I would. Just because if somebody resigns, there is always a risk of a constructive dismissal claim. And if there is a constructive dismissal claim, probably what they will be arguing about is that they've been treated badly in the disciplinary process. If you go through the process and you finish it, then, and if there is any way that they are going to succeed on a constructive dismissal claim, then what you can do is limit any liability by saying, well, it's all very well that they've been unfairly dismissed at this stage, but they would have been fairly dismissed in however many days once we had finalised this disciplinary process. And that's really good evidence in order to limit any liability if it goes any further. Right, that's the last question, so I'm going to hand you back over to Liz. Thanks, everybody, for listening.
Thank you, Helen. That was a lot of information there, wasn't it? Thank you very, very much. All sat here with bated breath, I think. If you want to ask Helen a question, then please, as she said, contact her direct. I will put the details on the email that I'll send through to you with the slides and the recordings. So thank you very, very much. Great to see you all again, and look forward to seeing you all again soon. Be turning off the webinar shortly, so once there's no more comments and messages coming through. Thank you very much, everybody.